Welcome to SCOTUScast, Civil Forfeiture and the Right to Assistance of Counsel Edition. Thank you for tuning in. On November 10, 2015, the Supreme Court heard oral argument in Luis v. U.S. Luis was indicated for Medicare fraud involving alleged kickbacks to patients who enrolled with Luis's home health care companies. The government then brought a civil action to restrain Luis's assets, including substitute property of an equivalent value to that actually traceable to the alleged fraud, before her criminal trial. Although Louise objected that she needed these assets to pay for defense counsel, the district court ruled in favor of the government, and the U.S. Court of Appeals for the 11th Circuit affirmed. The question before the Supreme Court is whether the pretrial restraint of a criminal defendant's legitimate, untainted assets, those not traceable to a criminal offense, needed to retain counsel of choice, violates the Fifth and Sixth Amendments. To discuss the case, we have John Malcolm, who is director of the Edwin Meese III Center for Legal and Judicial Studies, and the Ed Gilbertson and Sherry Lindberg Gilbertson Senior Legal Fellow at the Heritage Foundation. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. Malcolm.
On November 10th, the Supreme Court of the United States heard oral argument in Luis v. United States, a case which involves the issue of whether the government can restrain a defendant's assets prior to trial for possible forfeiture upon conviction, even if there is no proof that those assets are connected to any illegal activity, and when doing so would deprive the defendant of her ability to retain counsel of her choice. Sila Luis ran two highly successful companies in Florida that provided home health care and physical therapy to Medicare patients. She took dozens of trips overseas, mostly to Mexico, bought luxury cars, and gave millions of dollars to her husband, children, and other family members. In 2012, Luis was charged with conspiracy to commit Medicare fraud by paying kickbacks for patient referrals and by billing for services that either were not necessary or not actually performed. As part of this alleged scheme, the government claimed that Luis received $45 million in fraudulent reimbursements over a 6-year period. The government asked the trial court to freeze all of Luis's assets, including assets that were unconnected to the alleged criminal activity, relying on a federal law, Title 18 United States Code, Section 1345, that authorizes a court to restrain assets up to the value of the assets allegedly illegally obtained by violating federal health care laws prior to trial, when the government can show that the defendant has disposed of the proceeds of the alleged crime, which the government did in this case at a hearing before the district court. Luis requested permission to use some of her untainted assets to pay her attorneys in her criminal case, but that request was denied by the court, which analogized Luis's situation to that of a bank robber who steals $100,000, spends it all, and then wants to spend an additional $100,000 of untainted funds to hire her preferred lawyer, which would make it impossible for the bank to recoup its funds upon conviction. That ruling was affirmed by the 11th Circuit. The Sixth Amendment to the Constitution guarantees that a criminal defendant has a right to the assistance of counsel for his defense. What the court must decide is whether freezing Luis's untainted assets violated the Sixth Amendment right by depriving her of the right to the lawyer of her choice in her criminal case. While the government concedes that the right to hire the attorney of one's choice is at the heart of the Sixth Amendment, it argues that this right is not absolute. After all, you can't hire a lawyer who has a conflict of interest or whose fees you cannot afford, for example. According to the government, such limits are the incidental consequence of restrictions that serve legitimate and important public purposes. Additionally, the government points out that the court has previously ruled that a defendant cannot spend assets that are allegedly connected to the crime, so-called tainted assets, on an attorney, and that freezing such assets pending trial is permissible under the Constitution. The government argues that the same reasoning applies with respect to Luis's untainted assets, because under the federal health care statute, if Luis is convicted, the government would be entitled to forfeit property of equivalent value as substitute assets for her ill-gotten gains if it can be established that the defendant dissipated some of her tainted funds. The government argues the criminal forfeiture is a way of punishing the defendant by taking away the proceeds of the crime, and that because money is fungible, the government's right to punish Louise should not be limited to just those funds that are traceable to the underlying crime. Otherwise, a defendant like Louise could immediately spend everything that she obtained by committing a crime, but keeping all of her other assets. The government adds that nothing is stopping Louise from hiring the lawyer of her choice, but acknowledges that the lawyer wouldn't get paid up front and might never get paid. Not surprisingly, Louise emphasizes the importance of a criminal defendant being able to choose his or her own lawyer, which bolsters the public's confidence in our criminal justice system. She argues that a statute that allows for the pretrial freezing of untainted assets deprives a defendant of her right to her preferred lawyer and ultimately undermines the adversarial system of justice, something she claims would have been inconceivable to our founding fathers. Louise acknowledges that in 1989, in two cases, United States versus Monsanto and Kaplan and Drysdale versus United States, the court upheld the propriety of a pretrial order freezing tainted assets, even though doing so might deprive a defendant from being able to hire his or her preferred counsel. She argues, however, that there is a difference between tainted and untainted assets, in that tainted assets never legitimately belong to the criminal defendant in the first place, while untainted assets belong to the defendant, and the government cannot claim any ownership interest until after she is convicted. The last time the court took up a case involving the pretrial freezing of forfeitable funds was 2 years ago. In that case, Cayley versus United States, the court held 6-3, with the Chief Justice and Justices Breyer and Sotomayor dissenting, that a couple whose assets had been frozen, which prevented them from hiring their counsel of choice, did not have the right to challenge a grand jury's determination that there was probable cause to believe that they had committed a crime that could lead to forfeiture. At oral argument, both lawyers, Howard Shrebnick on behalf of Silva Louise and Deputy Solicitor General Michael Dreeben, arguing for the government, faced tough questioning from the justices, making the outcome difficult to predict. The justices appeared to be highly skeptical of Shrebnick's argument that there is a big distinction between tainted and untainted assets. Justice Kagan, for instance, stated that, quote, "It seems that the distinction you're making is one the court explicitly rejected in Monsanto and Kaplan and Drysdale." And the Chief Justice added, quote, "If you can freeze tainted assets without running afoul of the Sixth Amendment, I don't understand why you can't freeze untainted assets." Justices Alito and Kennedy also stressed the fungibility of money and expressed reluctance about adopting a rule that would encourage criminals to spend tainted assets immediately while hoarding their untainted assets so that they could hire a lawyer of their choice if they get caught. Justice Ginsburg noted that the statute in question did not distinguish between tainted and untainted assets. And Justice Sotomayor asked whether the rule that Shrebnick wanted the court to adopt could be applied in practice by district court judges who might be forced to monitor whether the amount of untainted assets that the defendant was spending on private counsel was reasonable or unreasonable. Both of them appeared concerned that adopting a rule that says that a defendant can spend untainted assets on whatever she wants because until the government obtains a conviction, it's her money. And Justice Scalia wondered whether the defendant might not have an equally good claim to seek a court order to unfreeze untainted assets in order to exercise other constitutional rights. When Shrebnick stressed the importance of the Sixth Amendment and that the defendant's immediate need for a lawyer following an indictment was paramount, Scalia seemed skeptical and said that he didn't know how you can limit your principle to the Sixth Amendment. Deputy Solicitor General Dreeben argued that there is not a clean line between tainted and untainted assets, and that if the government can get the money at the end of the day, it must be sure that the money will be available. some of the justices appeared concerned about this line of argument too. The Chief Justice and Justices Kennedy, Breyer, and Sotomayor, for example, wondered whether states and the federal government could expand this rule to all sorts of other crimes, effectively freezing all of the defendant's assets based on an unproven allegation, one based only on a finding of probable cause, thereby preventing him from retaining a private lawyer, unless, of course, the lawyer is willing to take the representation on a contingency basis. Dreeben acknowledged that this was at least a theoretical possibility. And Justice Kagan stated that the government's argument was pretty strong, given Monsanto and Kaplan and Drysdale, but she suggested that she was uncomfortable with those decisions, suggesting that she might be willing to reconsider them. Whether any of the other justices would follow her lead remains to be seen.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.